Good evening. Welcome to Money Mondays, a four-part series on legal rights and options during the COVID-19 pandemic. At Legal Services, we are a voice for justice. We provide free legal services to improve lives, promote fairness, and create opportunities for those in need across 21 counties in Missouri. We believe that community partnerships and cross-collaboration are essential to providing quality legal services. We are proud to partner with the St. Louis Regional Financial Empowerment Coalition and Money Smart Month to bring you reliable information during this pandemic. We hope you had an opportunity to view last week's discussion on stimulus payments, Missouri Circuit Breaker tax credit, and ways to access these tax benefits faster. We'd like to inform you of recent updates about stimulus payments before we begin today's session. People who do not usually file taxes can now complete a short form on the IRS website to request a stimulus payment. The website will also have information on how to add bank information to for those who want to receive their payments faster. Additional information can be found at irs.gov/coronavirus. The link to this website has been added to last week's post. This evening, we are grateful to have Ms. Susan Alverson with us to discuss your housing rights and options during the pandemic. Ms. Alverson will try to answer live questions at the end of the presentation, but please note that our speaker will not be able to see your questions and comments while she is speaking. For this, we extend our warmest thanks to the staff members at the Equal Housing Opportunity Commission who will help us address your concerns and questions in the chat section. I will now turn the presentation over to Ms. Alverson.
Hi, everybody. Thanks for coming this evening. I'm here to talk about your rights as tenants, the rights that you've always have, as well as the new rights due to this horrible health crisis that we are under. Next slide. So what I want to talk to you about this evening are three different things. First, I want to remind you about all the rights that you have right now and that you have had for decades. Mainly, I want to talk about what a legal eviction is because so many people are afraid of evictions right now. We're also going to talk about some recent court orders that have given you some additional rights and information. And lastly, a federal law that just went into effect on March the 27th. Next slide. So many of my clients want to know, what is a lawful eviction? And this is important information because there is so much misinformation out there. Your landlord could ask you to vacate and you could voluntarily leave. But if your landlord is demanding that for you to vacate, or is giving you a notice to vacate, or is giving you what's known as a notice of lease termination, that doesn't mean that your landlord has a right to just throw you out. A landlord may only lawfully evict you by going through the court process. What this means is your landlord must first file an eviction lawsuit. Then there will be a court date. In court, only if the landlord prevails after a trial can a landlord obtain a court order for your eviction. Now, your landlord may also obtain a court order for your eviction if you fail to go to court then a default judgment is issued. Or if you go to court and you agree to vacate and sign something called a consent judgment. Whether it is after a trial or after a default judgment or pursuant to a consent judgment, there must be a court order for your eviction. And lastly, only a sheriff has the right to enforce that eviction order and to carry out the eviction. So again, a lawsuit must be filed by your landlord. There must be a court order, and only the sheriff can execute the eviction. You will know if your landlord files a lawsuit against you because you would receive a summons to court. You would receive this summons either through the mail, posted on your front door, or hand delivered to you by a sheriff or special process server. Remember, for a legal eviction, there must be a lawsuit, a court order for the eviction, and only a sheriff can enforce that court order. Next slide. This means that self-help evictions are always illegal, always illegal. What do I mean by a self-help eviction? I mean an eviction where your landlord just comes over and changes your locks, or your landlord goes into the basement of your dwelling and disconnects some utility, or your landlord calls the water company or another utility and asks them to turn off the utilities in a way to force you out. These are all illegal. Again, your landlord has to go through the court process and obtain a court order for your eviction in order for your landlord to have the lawful right to legally evict you. So, if your landlord attempts an illegal lockout or just threatens to do so, then what you need to do is call Legal Services of Eastern Missouri and call the police. You're calling the police because the police should keep order. You are afraid of the landlord physically pushing you out the door and changing the locks. The police are there to keep order. And also, in addition, in the city of St. Louis, an illegal lockout is a crime. And because it's a crime, this means your landlord can be arrested, charged, and prosecuted with the crime. But whether you live in the county or the city or anywhere in Missouri, remember, this law is true for all Missouri citizens. A lawful eviction requires a court order, and a lockout is always illegal. Next slide. Now, because of this crisis that we are under, and with the orders to stay home by various cities, by state, then we have a situation where the Missouri Supreme Court decided to close all in-court proceedings. And this means all eviction proceedings. All of this is closed until May 1st. This not only applies to the Missouri Supreme Court, it applies to all of the circuit courts, all of the county courts in Missouri where landlord-tenant actions are and eviction actions. It is certainly possible that a landlord may be filing a lawsuit during this time that the courts have been closed. But even if a lawsuit is filed, there will not be a court date until after May 1, because May 1, 2020 is when the Missouri Supreme Court has suspended all eviction proceedings. Next slide. Now, some of you may say, well, I was in the middle of a lawsuit. And in fact, I had a court date in March or in April, and it was even a trial date. What about me? Well, the court should have given you notice of a continuance date. You should have received that through the mail. And if you haven't received that, you can go on a public internet site called CaseNet. We've listed it here for you. If you go to CaseNet, and if you know your case number, for your landlord's eviction lawsuit against you. And if you don't even have that, you can just input your name under the tab, click on the tab for litigant. That means people involved in the lawsuit. Type in your last name, your first name, the year of the lawsuit. You should be able to see the lawsuit, and under the docket tab, you should be able to see what the next court date is. Certainly, you may call the courts. We've listed here the court website for St. Louis County Court, as well for St. Louis City Circuit Court. Next tab. So it is possible that you fall into a category where not only had your landlord filed a lawsuit against you, but before the courts were closed, your landlord had obtained a court order against you. For St. Louis City Circuit Court and for St. Louis County, the sheriffs are not performing the evictions. They're running their moratorium on evictions through the time of the Missouri Supreme Court through May 1st. If you're in St. Charles County, it's going to go at least through April 17th. For other Missouri counties, unfortunately, it is possible that even though the Missouri Supreme Court has ordered the courts closed, nonetheless, a landlord in that county may be able to ask the sheriff to carry out an eviction order for an eviction order that already occurred prior to the court's closing. It won't just happen without you giving a notice, however. The sheriff will go to your front door and post a notice, giving you notice as to the date and time that the sheriff will be coming out to execute and enforce that court order. Next slide. Now, the third thing I wanted to talk about was some additional rights that tenants have because of a new federal law called the CARES Act, which was enacted by Congress on March the 27th. This act, the CARES Act, protects all tenants living in federally subsidized housing and federally supported housing. It protects tenants from new lawsuits being filed and that are about non-payment of rent. Next slide. Some of the listed housing, public supported housing, could be public housing where the housing authority is the landlord, HUD housing, low-income housing, Section 8 voucher holders, low-income housing tax credit properties known as LIHTC, and other federally supported housing. These are some of the most common. Next slide. So the CARES Act has created a 120-day federal eviction moratorium. It started on March the 27th, and it'll run for 120 days through late July. And during this moratorium, landlords cannot file eviction lawsuits, they can't issue late fees, and they can't even give tenants notices to vacate based on the claim of non-payment of rent. They're prohibited from filing new lawsuits, charging you for late fees, and filing new lawsuits claiming non-payment of rent, all during this 120-day period. And after the moratorium ends, which might be extended, they also must give an additional 30 days notice to vacate. So they have to wait another 30 days before filing that eviction lawsuit. Next slide. Unfortunately, the CARES Act does not apply to every tenant. It doesn't affect a situation where a lawsuit was filed before the moratorium. So for lawsuits filed before March 27th. It doesn't affect tenants living in non-federally supported housing. So where there's a solely private landlord tenant situation and you're paying fair market rent. and where the eviction is based upon another reason besides non-payment of rent. So if the tenant is up to date on the rent, but the landlord has been seeking to evict the tenant and terminate the lease for other reasons other than non-payment of rent. Next slide, please. Now, for a lot of folks, there's a whole issue of what to do about paying your rent. And this, of course, is the situation caused by so many people losing their jobs during this crisis we are in. So what you should do is some suggestions. First of all, inform your landlord. Inform your landlord that you've had a loss of income because of this crisis, and thus you are unable at this time to pay your rent. Ask your landlord for a payment plan, or perhaps a deferment of all your payments, for your payments to start at a later date, let's say sometime in September when, for instance, you might be getting a job back. Whatever agreement you do reach with your landlord, it's so important that you get it in writing. You want to have it dated and signed by your landlord if possible. Now again, because so many things are closed down and even the landlord's office, you may not be able to meet with the landlord in person and obtain something in writing, but at least you should be able to get confirmation of an agreement through text messages or email. You need something in writing to substantiate this agreement. So make sure that you have at least a text confirmation or an email. And for any payments you might make during this time, always make sure you get a rent receipt that's signed and dated by your landlord. Again, maybe you're not going to be able to see your landlord directly during this time, but at least make sure that the rent payment has been confirmed and acknowledged by your landlord through a text message or an email. And also, your landlord should not be charging you late fees for your non-payment of rent that's due to the loss of your income because of this crisis that we're in. So ask the landlord to waive all late fees. And if you get that agreement, make sure, again, it's in writing, confirmed by your landlord that they're waiving the late fees. Next slide. There's also some other resources that you may be able to apply for during this time. You may be able to apply for food stamps, known as SNAP. You may be able to apply for unemployment benefits and for utility assistance. Remember, even if you're not protected by the CARES Act, however, the Missouri courts are closed, all of them, until May 1st, which means there's not going to be a court date until after May 1st. That gives you some time to try to come up with some creative ideas or to set aside some rent money. Next slide. If you're living in federally subsidized housing, as I had listed before, like public housing or Section 8 or low-income housing, your rent could also be affected. And you need to also make sure you are notifying your landlord, the property management company, if you're in public housing or Section 8, that you're notifying the housing authority of the loss of your income and requesting that your rent be set based on your actual income. Make sure that when you do this, you can call the housing authority, you can leave a message, but that's not good enough. You also need to make sure that your notification is in writing. So send a notification by email or by text message. Now, the housing authority offices may be actually closed right now, but they're still open for business. The staff is still there. So that doesn't mean that since the building is closed that you can't contact your caseworker. Contact your caseworker, leave voicemail messages, send email messages. You're going to need this to make sure that you've given notification about the loss of your income. You can also look on your housing authority's website. We've listed here the two in the St. Louis area, the St. Louis Housing Authority and the Housing Authority of St. Louis County website. Look at the website for updates. No matter what you do, make sure that you realize that you are your own best advocate. What does that mean? It means you need to keep records, copies of your lease, copies of notifications to your landlord, from your landlord, to the housing authority. Make sure you have proof of all your rent payments. And if you can't get a receipt, make sure that you at least keep your money order stub. You're going to need all these records. Keep them in a safe place. Next slide. Now, during this time, your landlord still may give you a notice of lease termination, demanding you vacate, a notice to vacate, or other claim that you violated your lease for some other reason than non-payment of rent. Sure, that may happen. Those are just allegations. Nonetheless, it doesn't mean that the landlord has the right to take the law into his own hands. The landlord must go through the court judicial process in order to force you out legally. What does this mean? Again, your landlord has to file a lawsuit and obtain a court order and ask the sheriff to carry out the eviction. Your landlord cannot use self-help illegal measures like changing the locks or disconnecting your utilities. Don't forget to call the police if that were to occur. All these rights still exist. And there won't be a court process until after May 1st. Next slide. Besides the rights that haven't changed regarding what a lawful eviction is, there are also other rights that haven't changed during this crisis, and that is the rights that you have for fair housing. The fair housing rights are on the local, state, and federal levels. Fair housing prohibits discrimination against you on the basis of race or color, national origin, ethnicity, familial status, disability, sex, religion, and in the city of St. Louis, source of income. If you believe your landlord is discriminating against you, then you have the right to call any agencies listed below for help. These fair housing agencies are the St. Louis Equal Housing Opportunity Council, known as EHOC. We've listed their number, as well as the state Fair Housing Agency, which is the Missouri Commission on Human Rights, and then the federal Fair Housing Agency, which is HUD's discrimination hotline. Next slide. So if you are a tenant and you're needing help right now, call us at Legal Services. You may also complete an online intake. If you're a tenant living outside of the service area for Legal Services of Eastern Missouri, there are other legal aid offices you can call. Legal Aid of Western Missouri, Mid-Missouri, and Southern Missouri. We've listed their numbers here. And in the St. Louis area, there is EHOC that you can seek. They have a tenant hotline and also Arch City Defenders. Next slide. So you may have been asking questions while I've been talking. I've not been able to see them or hear them, but you can post your questions in our Facebook comments. Please don't leave any personal information. We will be attempting to answer your questions live, but not all of them can be answered now. This presentation and all the comments will be available on our Facebook page at Legal Services of Eastern Missouri. We also have slides and other resources available on our website at lsem.org/COVID-19 updates. So thanks again for watching. People, we're standing by to answer your questions. Thanks.
Thank you, Ms. Alverson, for that very helpful information. To all of our viewers, again, we are standing by to answer your questions. Feel free to add any questions or comments to the chat box, and we will get those to Ms. Alverson as soon as possible. Well, it looks like there's no questions right now. Again, thank you, Ms. Alverson, for that very helpful information. And thank you to each of you watching. Thank you for joining us for Money Mondays. Please join us for one of our future sessions. We'll be here on Facebook every Monday in April at 6:30 p.m. Next Money Monday, we'll connect with an attorney and business owner to discuss the new employment rules under the CARES Act. This includes small business loans and the Paycheck Protection Program. Then come back and join us on the 27th for a presentation about wills, trust, and estate planning tools to protect you, your family, and assets in case of an emergency. Today's session and recordings from prior events are saved on our Facebook page. Feel free to take a look. If you have questions about your housing rights, please feel free to call Legal Services of Eastern Missouri at 314-534-4200 or toll free at 800-444-0514. For additional COVID-19 resources and updates, please visit us online at the address provided in front of you. You can also follow our Legal Services Facebook page for additional legal information and updates. I'm sorry, we did receive some extra questions. So Ms. Alverson, if you have a moment. One viewer asked, can you please clarify what you mean by low-income housing as a type of housing compared to Section 8 or as opposed to Section 8?
Low-income housing is actually a term that my clients use when referring to something called project-based Section 8. I mean, essentially, most people, when they use the term Section 8, are referring to having what's known as a housing choice voucher, which is administered to them by a local housing authority. If you're living in project-based housing, also known as low-income housing or HUD housing, the housing authority is not involved at all. HUD is subsidizing the rent. Your rent is based on your income, and HUD administers this money through a state contract administrator. In Missouri, in most of Missouri, it's administered by the Missouri Housing Development Commission. So the money comes from the federal government, from HUD, which is the United States Department of Housing and Urban Development. It's issued to the Missouri Housing Development Commission, and they issue the subsidized rent to a private landlord. Your rent is based on your income if you're living in that complex. Your subsidy runs with the unit. It doesn't run with you. That's why it's called project-based. Unlike a Section 8 voucher that runs with you. So your voucher is yours. You can apply your subsidy to any unit. If you find a landlord to rent to you, you can port that Section 8 voucher assistance to another state. That's not the case for project-based Section 8, which is, again, also known as low income or HUD housing. I hope that answers your question.
Susie, we have another question. Are
Okay.
utility companies currently doing any utility shutoffs?
Could you repeat the question?
Are utility companies doing shutoffs right now?
They're not supposed to be. I mean, right now, both Ameren and Spire, Ameren, which issues electric service, and Spire, which issues gas service, they're not supposed to. They have imposed their own moratorium. I can't speak for, and American Water in the county isn't, and the St. Louis City Water Company isn't. I can't speak for the other water companies in the rest of Missouri. I would say you call the water company and find out whether or not they've issued a moratorium.
Thank you for that. One more question. What should I say to my landlord if he or she is threatening to evict me?
Well, again, that's that problem with that broad term evict. What the person is probably saying is they're going to file a lawsuit against you. And again, they could file a lawsuit against you right now, but the court's not going to give a court date until after May the 1st. If your landlord attempts an illegal lockout, call the police. If you're living in the St. Louis area, Jefferson County, St. Charles County, any of our service areas, call Legal Services of Eastern Missouri. What your landlord is, again, probably saying is, I'm going to evict you to scare you. So what you know is down the line, a lawsuit may be filed against you for rent. I would say try to talk to your landlord about a agreement. Ask about the deferment of your rent payments to a later time. And if your landlord is just refusing to deal with you, know this. Number one, your landlord cannot use illegal methods to evict you. And number two, they have to file that lawsuit against you. If the lawsuit is filed, you have a right in a rent possession lawsuit. That's the type of lawsuit that landlords file when they're claiming tenants owe rent. You have the right to defeat that eviction lawsuit if you pay all the rent that's due. It's the right to pay and stay. After all, if you've paid off all the rent, you can't be evicted. So that is a right that you want to remember. And that does not include having to pay for your landlord's attorney's fees. It doesn't mean paying for late fees. It doesn't mean paying for anything other than the rent that's due at that point, as of the date of trial, not the first court date, which is not the trial date. Now, unfortunately, your landlord could set it for trial in a week, but it's at the trial date. If you have all the rent the landlord's claiming, you can defeat an eviction.
Thank you, Susie. We have another question. What if I can pay part of my rent, but not all of my rent? Does my landlord have to take a partial payment?
Okay, in normal times, no, your landlord does not have to take that partial payment. But if you have your rent money, set it aside and do not spend it. It is so easy to have the temptation of having it, the landlord won't take it, and so you spend it. Put it aside. Again, you have that right before the landlord can get a court judgment against you for eviction to pay all the rent the landlord is claiming. But you can also appeal to common sense of a landlord. Accept the rent money. You can appeal to the common sense of the landlord to just enter into a payment agreement. And again, whatever you do, don't believe that you have an agreement if it's one-sided. You need to make sure that the landlord is in on this. The landlord has agreed. Something in writing, like I have said, even if it's a text message confirming, yes, I agree. You don't have to pay me anything in September until September, and then I'm going to let you double up. Something like that. Get it in writing. But you can't force it down their throat, not the partial payment.
Thank you, Susie. We have another question. How will a tenant know if the housing is covered by the CARES Act? For example, if there's a federally backed loan or something that is not as obvious as being in the Section 8 program or in public housing?
That is a very good question. Well, and we're gearing up for dealing with that. It is also the case that federally insured mortgages are covered. So if your landlord doesn't have a private mortgage, but has a federally insured mortgage, then that 120-day moratorium also exists. It's going to be a question that you will have a right to ask the landlord if the landlord sues you for rent during that 120-day period. It's not obviously federally subsidized because you don't have Section 8, it's not public housing. You would have the right to ask the landlord whether or not it's a federally insured loan. That may be something that's available on the Recorders of Deeds, which is a public information site. All deeds filed and loans filed on any real property is disclosed at the Recorder of Deeds office. And maybe if you get a copy of what's known as the deed of trust or some other mortgage instrument, it might be on there. It's a difficult one.
Thank you for that answer, Susie. Again, if you have any questions or comments that you would like Ms. Alverson to address, please feel free to drop those in the chat box. So I don't see any new comments or questions. Thank you again for attending this Money Monday presentation. Please come and join us next Money Monday for our presentation on small business matters. Thank you and have a good night.
Bye-bye. Night.